The family of 6 will now have to leave the Dartmouth duplex they've been renting after their landlords won an appeal to be able to move in their daughter. A small claims court adjudicator previously said they could have difficulties finding another home during a housing crisis, and it was inappropriate to disrupt their 13-year tenancy. But a Nova Scotia Supreme Court judge decided however well-intentioned that interpretation was, it was incorrect, and risks a decision-making process which becomes vulnerable to one person's subjective views, slips towards a decision which is more arbitrary than judicial, and dramatically tilts the legislated balance between landlord rights and tenants' rights in favor of the tenant.
They're excited, obviously, to be able to assist their daughters going forward, assist them when they're starting their next chapter of their life, particularly their daughter that just recently got married.
The lawyer for the landlord says additional tests by the lower court as to whether taking back the unit is appropriate were never used before.
And so that portion of it was removed by the Supreme Court on appeal, and the focus then has gone back to what it was traditionally in whether or not there's a good faith need for the unit for themselves or a family member, which was found to be the case here.
Nova Scotia Legal Aid represented the tenants. It respects the decision, but says the lower court did raise a critical issue many tenants are facing.
So the court was concerned about the lack of evidence of the housing crisis before them. It's not that we can't recognize that there is a housing crisis.
She thinks legislation could be changed to factor in the housing crunch. The tenants are disappointed and say they felt blindsided from the beginning of the process, but are now hoping to find a place that's bigger and works better for their family before they have to leave the unit in August. Gareth Hampshire, CBC News, Halifax.